Good evening. Captain Retired Matt Edwards here with the next installment of my Observation Post Facebook Live weekly broadcast for the 25th of May, 2023. Started a bit early. That's the thing when I'm not getting paid to do this. I'm just, trying to educate the public about many of these things that I'm trying to get changed. So I'll probably try to do it in 25-30 minutes if I can. And when I was getting ready to start it, I thought, maybe I'll do a short point about some of the things that I always talk about, just in case people don't know what I'm talking about. For example, I'm always talking about clawbacks. A clawback is when you take the information, someone gives you information, the government or some company, and then because they have the information that you're getting another payment, they reduce the payment they're giving you. And it's downright sneaky because they don't have the right to do it many times. Not in law, not in equity. It isn't fair. But they think they have people convinced that it is fair and they get away with it. So clawbacks are the bane of many people's existence. Shouldn't happen. Now, another one that I'm always talking about is compensation. Compensation can be compensation for your time when you get paid for your services if you have a job. But it can also have a different connotation. If you get injured, you get compensated, you get made whole by a capital payment. Unlike income, which is the compensation that I use with the small c, the capital C one is when someone pays you a capital payment to replace a capital loss. Anyway, just throwing that out there and figured I'd, Oh, and maybe one more. The Service Income Support Insurance Plan I'm always talking about, which is known as CFSA. That is a federal long-term disability insurance brought in 1969, and it was created as a non-public property entity under National Defense Act, Section 39(1). Now, I was thinking about that day, which is why it popped into my head, and because it's a non-public property entity, it isn't the government's money. It was created with the premiums from Canadian Forces members. From 1969 to 1971, it was completely paid by the Canadian Forces member. After 1971, when the public service introduced their long-term disability insurance, which was a 50-50 split on the payment, they made the Army's long-term disability the insurance that the soldiers were paying 100% of, and they made it 50% government and 50% by the Canadian Forces member. Now, if you think about that, that creates a benefit of sorts for the people who opted to buy into the insurance because the government paid for half of it, and the people who decided not to buy into it, they didn't get the additional benefit. So you could think that that's not fair. But I would disagree, because in 1982, when the government made it mandatory, they took away freedom to contract. Because you ought to be able to walk away from a contract, like the people who chose not to buy into the insurance. If you don't buy into an insurance, you walk away. That's called an adherence contract. Anyway, now on to my points. And I've got a column I wrote that I didn't post yet. Maybe I'll read it out if I feel like it. Number 267 on the list I prepared. Tax expenditures. Now, why I decided to review a few points before I started was I was thinking maybe I'll make tax expenditures one of the points, which I'll do now. Finance Canada publishes a report each year on things that the government could collect money on in taxes that it chooses not to. And they call these things, perversely, tax expenditures, when I would think, and maybe you would think, a tax expenditure is how they spend the government's taxes that they collect. It seems like a very stupid notion to me. So anyway, that's what tax expenditures are. Tax expenditures and clawbacks. Finance Canada fails to recognize the lost taxes on a clawback. Now, the reason I put that there is I believe this proves my point. that there's no such thing as, clawbacks being fair, and because they're a form of tax. In the 1998 Finance Canada Tax Expenditures report, they said that clawbacks are a form of tax. I put my thinking hat on because they didn't explain why, and I figured out they were talking about the fact that taxes would be expended if they didn't claw back something from the program payment. So they save taxes. They have to spend more taxes if they don't claw back. That's what I believe why they included clawbacks as a form of taxation in their report. Now the thing is, I have Sun Life take about $1,000 a month from my insurance because of my Canada Pension Plan disability. They also take about $1,500 a month off because of my Public Service Superannuation Act pension. Now that's $2,500 a month that would attract taxes if they had to pay me the full amount of the insurance. Now that would be a Finance Canada tax expenditure. So the government is losing the tax revenue because the insurance is clawing back other pensions. Now, in the case of the government, that results in, they'd say, who cares, because we save on the insurance. But what about companies and, just private employers that they have a group long-term disability, the person becomes disabled, then they get forced into getting the Canada Pension Plan disability. They might have a private pension from their employer, so their insurance goes down. But if they did it right, the government will get more taxes because the insurance would have to pay in addition to the pensions, because they are both, or all, non-indemnity and contributory. Pensions are property, insurance is property, so you can't reduce one because of another. Now, I'm planning on bringing this up to the Member of Parliament one of these days, knowing that it's probably a waste of time, because they have the game fixed as far as I'm concerned. They should, for those tax expenditure reports, they should stick to the basics. They should, if they want to do it, they've developed this system. If they want to do it, they ought to do it right. For example, they should include what I just said. If they're going to say that they're foregoing taxes on lost revenue in taxes, then they should include the things I mentioned. Now, maybe they're there and I didn't see them. But I have reviewed many years of tax expenditure reports, and I haven't seen one for clawbacks. 268. Bridging. Examine bridging in relation to the disabled and the able-bodied to see which group is shafted the most. See, there are two groups that get shafted with the government's notion of bridging. There are people at age 65 who lose bridging according to the law. In the Canadian Forces Superannuation Act, the RCMP Superannuation Act, and the Public Service Superannuation Act, there is a thing that says if you get the Canada Pension Plan, you lose part of your pension. Now the thing is, this is illegal. Illegal, immoral, unjust, unfair, and it goes against the spirit and intent of the Canada Pension Plan Act, because Minister Judy LaMarche in 1964, on the 9th of November 1964, this is a record in the Hansard, and I found it. You could, anybody could. And a Mr. Chatterton, a Conservative Member of Parliament, said to Minister Judy LaMarche, what's going to happen if a public servant becomes disabled and they have a Public Service Superannuation Act pension and they're going to get a Public Service Superannuation Act disability pension? Will they get the Canada Pension Plan disability in addition to their Public Service Superannuation Act pension? And he obviously wanted the answer to be no, or they'd only get part of it. But she said, good on her, of course, he'll get them all. If he had 5 or 6 pensions, he'd get them all. Now, again, she didn't explain it. I do believe she was a lawyer. I wish she had said, well, it's because pensions are property, and we can't interfere with the person getting back their property. Because pensions are also trust funds. So the administrator holds the money on in trust until you retire. And then they have to give the money back to the person who retired. So if you gave the person part of the money back instead of all of the money back, you just breached your fiduciary duty because you ripped them off. You stole their money. Now, the government made a law to try to say it's legal, but it's not legal in the common law, and pensions happen to be provincial in exclusive jurisdiction. So the federal government, which is a federal law, says that they can steal your money, but they didn't have the jurisdiction to write that law. Now, I'm sure this must have occurred to somebody besides me. So how come none of this came out before and they didn't fix it? Because the longer it goes without fixing, the more expensive the fix will be. You know, it's going to cost them a lot of money to fix this. But so far, they just continue to keep ripping people off. And as I was explaining to my member of parliament staffer I was talking to for about 50 minutes yesterday, the general public thinks that bridging is a bonus, a perk for the public servant, the Canadian Forces member, and the RCMP member. But the people getting these pensions thinks it's a penalty. So you have a widely different view depending on your perspective. If you're a public servant, a soldier, or a policeman, you know you're getting fucked over. If you're a member of the public, you're saying, how come they get such a good pension? Why do they get such special treatment? That has to stop. So this is how they're getting away with it, I think, because they have everybody bamboozled. They have the pensioners thinking, well, it's the government, they can make whatever law they want. And you had the public thinking, well, the government gets all this special treatment, they makes the law for themselves. Anyway, carrying on, number 269. Decouple the Canadian Forces Superannuation Act / Public Service Superannuation Act / RCMP Superannuation Act with the Canada Pension Plan. Now, this is a related point to the previous one, and I'm talking about Bill C-73 in the year 2000, which was one of the laws that I happened to come across. They don't become a law like the Canada Pension Plan Act without being a bill first and having them discussed, debated, and then voted on. So back in 2000, they decided to decouple the Canada Pension Plan with the federal pensions. Now, if you ask me, that sounds an awful lot like we're not going to have bridging no more. Decouple. Separate. You know? But they didn't do it. So they announced they were going to do it, but the administrators are still deducting the value of the Canada Pension Plan. Now, I got to go back to the other point because I just remembered I missed the point. Which group is screwed over the most? The disabled or the able-bodied? At age 65, you're going to have your pension reduced. But the person who becomes disabled is forced into getting a Canada Pension Plan disability by insurance companies. When they get the Canada Pension Plan disability, then they lose it off of their insurance, and they also, by happenstance, lose it off their retirement pension. So the employer, which is the insurer, and the pension administrator benefits twice. But the point I'm trying to make is you get a much reduced pension at an earlier date, and you also get a reduced retirement pension, and then your insurance gets reduced by both reduced pensions. Now, see, there's something wrong with that kind of system. Somebody has perverted the whole scheme. The Canada Pension Plan was originally designed to provide up to 25% of your retirement needs. In actuality, according to the statistics, it provides 13.2%, which is about half of what they said they were going to make it. Now, then they'll say, well, we said up to. But see, the employers aren't filling in the slack, and they'd rather have what appears to be a public pension. But there's another thing I told the MP's office. Don't remember the exact date, like Judy LaMarche's point, but I came across recently a point where a member of the government or the opposition or the government or somebody in 1964 again said that this pension is a great pension. It doesn't require 1 red cent of public funds. In other words, the government's not putting a copper into the program that it created. So everybody thinks the Canada Pension Plan is a government program, but it's actually not. It's a program which is self-funded by the Canadian citizen, and the people that work there work for the government, and they get paid out of the funds that we pay into the Canada Pension Plan. They don't get paid by the government out of the Treasury Board Secretary funds. They deduct their salaries and administration costs and all the other stuff out of the Canada Pension Plan, which comes from public funds. So it's not a government income support program, really. It doesn't affect all Canadians. It only affects working class Canadians between 18 and 65. So you can contribute to the Canada Pension Plan 47 years. That's what it would take to get a maximum Canada Pension Plan. Anyway, next point. 270. Granovsky, Supreme Court of Canada, in reverse. Failure to be certified has a detrimental effect. Now, what I'm referring to is in that case in 1990, there was a guy who worked off and on, didn't have enough service to get Canada Pension Plan disability, took it to court, ended up in the Supreme Court, and basically they said, well, you have to draw the line somewhere in the law. And unfortunately, you don't qualify. You don't have 4 to 6 years worth of minimum qualification period. And they said getting certified as being disabled by the Canada Pension Plan is a benefit because you get money after you get certified. Now that caused me to think, how about if you apply for compensation for your injury on duty in the military, like I did, and they say you were hurt in service, which is fine so far, but then they revoke that certification later, and they said you weren't hurt in service. So now it's a liability because they refused to say someone was hurt in service. Then they can say we don't owe you anything, and then they don't pay you anything. So that becomes a liability, a deficit. Even my Canada Pension Plan disability, when I got approved, I lost $1,000 off my Sun Life insurance. I lost $1,000 off my Manual Life insurance. I lost a $500 payment off my public service pension and a $50 payment off of my Reserve Force pension plan. $2,550 less per month because I got an additional $1,000 a month, and that isn't a benefit. The judges might have said in the Granovsky case that it's a benefit, but it doesn't benefit Captain Retired Matt Edwards, and there's probably many more people like me that it doesn't benefit. Now, I think I know the answer to that, why that is the case. It's if you only have one payment, it's going to be a benefit. But if you have more than one payment and you have clawbacks, well, you could end up in the hole, so it becomes a detriment. Number 271. IRB, Income Replacement Benefit, has 2 gateways. A, medical release, and B, application after a non-medical release. Now, why I made this point is, well, I've been arguing with Veterans Affairs Canada a lot. And they made me apply for income replacement benefits, rehabilitation, whatever you want to call it, after they kicked me off of the program. I was originally in it on paper from November of 2012 till July of 2013. Then they kicked me off it because they said I didn't keep in contact with them, which I didn't. But I was very sick with diabetes at the time. Blood sugar was at 36, saying double. Now, when, where was I with that? Oh, when I was approved under the medical release gateway, because I was medical release on the 19th of January 2012, that's going to be my access to Veterans Affairs staff. Even if I don't get anything right away, it'll always have to be under that gateway because that's the way they designed the new Veterans Charter. So if you have someone who's released other than medical, because there are 5 release items, I'm not going to tell you all of them because I don't know all of them. I'd have to look it up again. But QRNO 3 is medical, 3A is you can't do any job after service, and 3B is you can't do your own trade after you're too disabled to serve. I think 4 is dishonorable. So if you get released anything other than item 3 under the Queen's regulations and orders, then you had to make an application. Veterans Affairs Canada has to adjudicate the file and determine if you were hurt in service. But they can't try to make the rules fit for someone like me that was medically released. Even if I'm not getting any payment, or if I'm not in the system, I shouldn't have to apply. They should just have to, yeah, you were medically released. Your gateway is the medical release. So therefore, give us your information and we'll see what happens. There shouldn't be an application where they have to look at it and they can try to say, yes or no, I was hurt in service. Because the same goddamn case manager who said I was hurt in service in 2012, a year or 2 later said I wasn't, with the same medical condition. Now, explain that to me, please. That's clearly absurd. Okay? Had it been a different case manager, I might have understood. Okay. Number 272. Going fairly quick. I might try to read that column that I never posted, but we'll see. Entitles as of right. Sarvanis. Now, what I was thinking about is the statement that Minister Lamarche said in 1964, that when a person who is in the Canada Pension Plan becomes disabled, they will have help as of right, an entitlement. Now, as I said to the Member of Parliament staffer the other day, if they had this plan to give people a Canada Pension Plan disability because they contributed to it, they're part of the pension, and they become disabled, and therefore, as Minister Lamarche said, when a beloved breadwinner becomes disabled and they can't contribute to the family income anymore, they're going to have this insurance to take care of them. Well, then how come 35 to 40% of the applications are approved and nobody gets it? See? So there's a disconnect between what the plan was and what is happening with the Canada Pension Plan, because the people paying the pension want to save money for the government, and they therefore don't approve people, even though, in my not so humble opinion about pensions and stuff, with the promise that was made by Minister Lamarche in 1964, if you become disabled and you cannot perform your own job, you should get the Canada Pension Plan disability. There shouldn't be a stringent definition of disability built into the Canada Pension Plan Act. Anybody who's too disabled to work for more than 12 months, because that's the definition, you had to satisfy 3 things to get the Canada Pension Plan disability. You had to be disabled, you had to be unable to work, and you had to be in that condition for at least 12 months. Section 44 of the Canada Pension Plan Act. So if that's the case, you should get approved whenever you're too disabled to work and you're off work a year. Doctor sends it in, they certified it, they put their John Hancock on it, therefore you had a government official, because doctors aren't private, a government official certified it. Instead, what they have is a series of checks and balances where they overrule the doctor, they find all kinds of technicalities, and then they make you appeal. Now, so many people get approved on appeal, but it's still not a high percentage. And the problem is, I believe, is that these idiots are not looking at pensions are supposed to be about fairness, equity, justice. It's supposed to be getting your money back. They're not supposed to be, you don't qualify because of a legal technicality. You didn't contribute 4 to 6 years, so therefore you're not going to get your money. Because that's breaching the fiduciary duty owed to the person who contributed. They have their money being held in trust by the administrator, and they're asking for their money back because they became disabled. Anyway, I think I'm going fast enough. I'm going to whip out that column I did and read it out. It's not posted yet. It's kind of a draft, but I think it's okay. I haven't been doing them lately, and I've been thinking maybe I should get back into publishing more stories, columns. What happens is that I do these things up, and then I think of something else, and I think of something else, and if I kept going, I'd never be done. That's one of the main reasons I haven't posted it yet. and I might have another column or two in that posted. I call this legitimate expectations because that's a legal doctrine about what I was just saying. If you become disabled and you contribute to the Canada Pension Plan, and they set the Canada Pension Plan up for people who became disabled, well, you should have a legitimate expectation that you will get approved and not denied. That's the genesis of it. The legal doctrine of legitimate expectation is an important part of the fairness or natural justice. Do disabled Canadians, and in particular disabled veterans, have a legitimate expectation? For example, in 1999, the Canadian government made a service income support insurance plan assisted policy 901-102 automatic on medical release after they had been using the wrong definition of disability before 1999. Shouldn't the Canadian Forces members who paid the premiums have had the legitimate expectation to get their insurance if they're too disabled to perform their duty? I think it's common sense. In fact, that's what they said in the 2003 Treasury Board Secretary Total Compensation Report, which is where I got some of these ideas. A closely related example is the injury on duty requirement for the disabled Reserve Force veteran who is told in contract, which they did not negotiate, that they cannot get CFSA policy 901-102 until they satisfy the condition of proving that they were hurt on duty, a near impossible task for invisible disabilities. Another shocking example is the payment of the Reserve Force pension plan only when the disabled veteran has approved they cannot perform the duties of any occupation, when the Canadian disabled regular force veteran has to, in law, only be able to perform, not be able to perform their own duties. I'm going to interject there because I told a member of Parliament's staffer yesterday, I said, you cannot have a law in the Canadian Forces Superannuation Act where you define disability as being unable to do your own trade. But in the Reserve Force pension plan, you have a law saying that you had to be too disabled to do any trade. You just can't have that in the construction of a law because they disagree with each other in the same enactment. Laws should not conflict, and policies as well. The Reserve Force pension plan requires the disabled reservist to apply for the Canada Pension Plan disability in order to access the property that they contributed during their career. This abdicates the adjudication of the Reserve Force pension plan to another government agency, which is an absurd dereliction of duty. In addition, I almost feel like I'm picking on the RFPP too much, but I can't pick on them too much because they're a bunch of idiots for not fixing this at the beginning. In addition, the Reserve Force pension plan has a career average formula instead of the best 5 years average salary being used to establish the amount of pension. So this is an illegitimate expectation on part of the government who saves at the expense of the Reserve Force veteran. The Veterans Wellbeing Act regulations claw back the income replacement benefit by the same things that the Service Income Support Insurance Policy 901-102 does, and this includes the property that is a pension. Even more disturbing is the fact that the Department of National Defence Insurance claws back the same things as Veterans Affairs Canada without taking the other clawback into account. Clearly, a double breach of peace of mind. However, the genesis of this column was inspired by the notion that legitimate expectations should merge with or include peace of mind. Insurance is purchased for peace of mind, a psychological benefit, and retirement pensions are also meant for peace of mind. A difference might lie in that insurance is sold in contract law and pensions are based in equity law. However, the courts have said that pensions are akin to insurance. That brings us to the end of this short piece and the problem, which arises when the principles of equity and justice intersect with technical and legal interpretation. After all, the Reserve Force pension plan, for example, is legally property. I put in brackets Clark Supreme Court of Canada, 1990. And the government is refusing to deliver that property unless a condition is met that has nothing to do with said property. Bridging is the reason for this policy choice, and that has to do with the employer saving money at the expense of the former employee. Surely there is no justice in having Canada save money at the expense of a disabled veteran who became disabled serving in the military, fighting or training to fight, or then I can't help it, I know all these cases, McKay, Supreme Court of Canada, 1980. What happened to the idea in the Pension Act that Canada owes a legal debt to the veteran The War Amputations of Canada, Ontario Court of Appeal 1997 case stated that the Pension Act was paid for 3 reasons. Number 1, sustenance, which I put in brackets as welfare. And 2, gratitude. So they're supposed to be grateful for the person losing something. And 3, debt, stated to be the most important point. And like I said, this is a draft, so I intend to put in there, like, if you're getting a debt payment, you're obviously not getting income. If you're getting an income replacement benefit to replace something that you're owed because the government owes you a debt, they can't tax it because they're not giving you a profit, an increase in your wealth. You're not getting paid for your time because you're serving in the military. You're getting a payment because you were injured on duty and therefore you applied for benefits, they call it, and you got a payment. Now, the payment is meant to, as the War Amputation of Canada case said in 1997, this is not Matt Edwards, it's to repay the debt that the nation owes to the individuals that put their life on the line for the nation, which is an entirely reasonable point. Correct? When you owe someone something, you have to repay your debts. If you watch the Game of Thrones, you know about the Lannisters. They said they always repay their debts. Well, Canada doesn't want to repay the debt it owes to a disabled and service veteran. They want to take into account the veteran's property and reduce the payment. Now, if that was legally or morally justified, that'd be one thing. But in 1973, a case called O'Reilly versus Flanagan, they came up the issue. They wanted clawback pensions in a lawsuit in tort in the common law. And the judge said, well, there's no principle in equity law that would allow the person who created the injured party to save at their expense because they have property and insurance and pensions. There's no justification that you can put forward that would satisfy a judge to say this is fair. That's what the person said. And in 2012, the New Brunswick J.D. Irving case, they were taking the Canada Pension Plan retirement into account to reduce workers' compensation. The court said, you can't do this. You're subsidizing the employer, which goes against the merit principle. Now, the merit principle is a set of rules, 4 or 5, that relate to workers' compensation, which is a replacement for the lawsuit in tort. In the old days, before workers' compensation came along, if you became injured on the job for an employer, you had a problem that first you had to prove that the employer owed you a duty of care, which isn't always the case because you're an employee, not some stranger. Then you had to prove that the duty of care was breached. And then you had to prove that damages resulted, monetary damages. All of that could be very stressful and hard to prove, and it was David versus Goliath, basically. So they came up with this workers' compensation scheme, and they traded the right to sue in order to get comprehensive and administrative compensation instead of tort lawsuit compensation. It was an exchange of rights, the right to sue for the right to compensation. Now, soldiers don't have a contract, but in 1953, they were talking about the Crown Liability and Proceedings Act, Section 9, in the Hansard, and they said that CLPA Section 9, which bars a lawsuit when you get a pension for your injury, that is directly the same as the workers' compensation system of exchanging the right to sue. So basically, the Pension Act was an exchange for the right to sue, and the government might think that the Income Replacement Benefit and other Veterans Wellbeing Act things are in exchange for the right to sue. But you know, I was about to clue up, but I will mention this last point. When Dennis Manouche, who sued the government successfully, and depending on who you say, at first it was 4,200 veterans that were part of the suit, then it became 10,000, then it became 14,000. I don't know how they came up with these numbers. Well, if CFSA was compensating you, like the Pension Act, for your injury, for your loss of income, then Crown Liability and Proceedings Act Section 9 would have applied, and like the government tried to when they asked the court to throw the case out, you would have been getting compensated by the Service Income Support Insurance Plan, and therefore Crown Liability and Proceedings Act Section 9 applied, and therefore you will be barred from suing, and Dennis was shit out of luck. But the Service Income Support Insurance Plan, as I continue to say, is a non-indemnity and contributory payment. Non-indemnity is the opposite of indemnity. Indemnity means to repay someone for their injury, to pay them damages, to make them whole. Now, if you're getting a payment that is non-indemnity, you're not getting a payment that is making you whole. You're not getting damages. You're not getting compensated. You're getting what you paid for. In contract, a formula is made, and then you get the payment because you bought the insurance. Unfortunately, the judge got it backwards. The judge said that the Pension Act was a non-indemnity payment and that CFSA was an indemnity payment. Now, the results would have been the same. If he had got it right and said that the Service Income Support Insurance Plan is a classic non-indemnity long-term disability insurance, just like the Salts British Columbia Court of Appeal case in 2006, a year ago. And the Pension Act, according to the intent of the legislators in 1916, according to the Ontario Court of Appeal, War Amputation of Canada case, and common sense, and the Hampshire from 1953, the pension is a replacement for a lawsuit in tort, and you get indemnified for your loss. But you see, you're allowed to get an indemnity payment and a non-indemnity payment at the same time without offending any legal principles. So whichever one is the non-indemnity payment and the indemnity payment can be looked at as moot, except for someone like me with obsessive compulsive personality disorder wanting everything to be 100% correct. So when a judge in the federal court makes that kind of mistake, it detracts from our trust in the system. Dennis would have won his case either way, because it didn't matter. It only matters to someone like me, because then I wonder, did the judge make the mistake on purpose? Was it a mistake at all? Or was he on a corrupt judge that just wanted the government to get away with it? Because he still gave the class the win, but he did it in an underhanded way. He did it in an unlawful way, because he is bound by precedent. In the common law, a judge is bound by previous cases and cases that are of a higher nature. Well, it has always been the case in Canada that if you get damages and then the insurance company wants to save money by taking into account a pension or insurance, the courts tell them to go fuck off. That this has always been off limits. You can't take someone's property into account, their pension or their insurance, into account simply because Buddy wants to save money on some kind of technicality. What's supposed to matter is fairness and justice, equity, right? That is the basis of tort law. So it should be, and I'll make this my last point, it should be the basis of workers' compensation, and it used to be. I remember reading a case, I can't tell you which one. It was a British workers' compensation case, and the guy died at home, but he was always working in the sewers, and he developed tuberculosis or something. So they gave him workers' compensation based on his debt. They said it was related to his work because they could see how that could lead to tuberculosis. Try that these days. We had a Canadian Forces member on her way to deployment in Afghanistan, and she got into a car accident, and her daughter or son got killed. She lost a leg. Veterans Affairs said she wasn't on duty. That's horseshit, okay? They shouldn't be relying on legal technicalities. They should be saying, what is fair here? Is it fair to deny a Canadian Forces member who was a mother and lost her child and lost her leg? Is it fair to deny her compensation for injury on duty? I say no. I say they were fucking wrong. They can try to say that we were right, the courts upheld our decision and all that. Go fuck yourself. What is the spirit and intent of these acts? What were they designed to do? They are not designed to save the government on legal technicalities. They are supposed to look at equity, justice, fairness, and according to the Interpretation Act, Section 12, a liberal and broad application of how you're trying to interpret something. So instead of saying that we're being technical here and that this person was technically not on duty at the time, she was getting ready to get deployed. Give me a fucking break. How is that not related to work, service, whatever? Anyway, on that note, I'm going to thank you for watching. And like I said, hopefully one of these days we'll get all this sorted out instead of me just ranting and raving on the internet, you know, broadcasting this. Hopefully one of these days we'll get some of this stuff fixed and some justice, you know, served. Thanks.